Welcome back to another episode of the Downsizing Roadmap podcast with your hosts, Jody Roscoe and Heather Fisher. We're talking about all things downsizing, from our own experiences with clients to guest experts. Let's make downsizing easier, one conversation at a time.
Welcome back to another episode of the Downsizing Roadmap podcast. I'm Heather Fisher.
And I'm Jody Roscoe.
And we are here today talking about an important topic for many seniors, and that is your estate planning. And we have a guest with us today, Rachael Houck with Houck Menninger Law. She is a certified elder law attorney and going to talk to us today about a lot of those pieces, what we should be doing and when, and get our questions answered. Welcome, Rachael.
Thanks, ladies, for having me.
Welcome. I think this is something that people either don't do at all and put off, or something that they do but they don't go back and look at again, and they just kind of think it's okay years later when it really isn't.
Yeah, I think that you kind of hit the nail on the head there. They say about 80% of the population of the United States has done no significant estate planning.
80%.
That is astounding to me.
Scary.
Yeah. So, and then the other 20% that have done something, typically, most of the time we're doing it, after we've had children, and then we don't go back and look at it, and now we've got kids that are adults that we've got guardians for them in our wills or
Right.
whatever. But yeah, I think that's definitely something that we see a lot. And people don't think about the fact that laws change too, right?
Right.
So if we're not updating those documents, what we wanted it to accomplish when we initially did it may not be what it's going to accomplish when we actually have to use the document.
Yes.
Yeah. And I think in my own family's experience, the best and easiest way to, protect your legacy or just have that plan in place is to do it well before the crisis, because everything is harder when it's a quick need for things to change. So, talk to us a little bit today about when is a great time to talk to, someone like you, and what we should be asking.
Yeah. Well, anybody who's 18 or over should have documents in place.
Name them.
So the 5 most important documents we typically discuss is financial power of attorney. Sometimes a general durable power of attorney is what it's referred to as. Healthcare power of attorney, living will, our HIPAA, and the burial representative. So those are the, what we call those ancillaries. And then also a will or a trust to kind of complete that. But those ancillary documents outside of the burial representative are really the documents that are going to give people the ability to make decisions or help you while you're alive. The other ones, wills and trusts, typically are for where things go when we pass away. So if 18 or over, you should have those documents in place. So kind of right now with kids graduating from high school, getting ready to go to college, that should be a gift that you really think about doing for your kids.
Yeah, so both of our kids, both of our girls went to college last year, and that was something that just kind of snuck up on me, and I was like, wait, I need to make sure if she goes to, if something happens to her, I can still be her mom, I've always been, and
and we don't think about it. People also who are married don't think about the fact that they're your spouse, but they can't make decisions for you, right? Legally.
Right.
Or access your bank account if it's not joint or something like that.
Right.
When you named the documents, what's the difference between the healthcare power of attorney and the HIPAA document? Those both have to do with healthcare, correct?
Yep. So your healthcare power of attorney is the document where you're actually appointing someone to be a decision maker for you. So you're the principal, you're the one creating the document, and you're appointing an agent. Typically in Ohio, we can only have one healthcare power of attorney, so we might list other names, so we would have successors. So if, for example, I had, my mom as my healthcare power of attorney, and for whatever reason she wasn't able to make decisions, they could go down to my dad as the next one, right? But only my mom, as my healthcare power of attorney, has access to my health information. So our HIPAA allows us to name other individuals who can actually obtain information the doctors can release information to them.
So release information, but they aren't making decisions about
Correct.
your health care.
That's right.
Got it.
Got it.
So, maybe you've got adult children and your husband, so you make your husband your healthcare power of attorney, but if you're in the hospital, you would want the kids to be able to call and check
Find
on
out.
you. Yeah. So that gives them access, but not decision-making powers.
Got it. So how does elder law, how is that different from, you're saying 18 and up, but then when we get to elder law, like what are the differences in that?
So elder law is really an area of practice. So you've got estate planning, and then under that umbrella, you've got elder law, special needs planning, those kinds of things. So elder law is really about helping families, whether they're seniors or disabled individuals of any age, right, who helping them plan for that potential future of a possible long-term care event, nursing home or something of that nature. It interplays with things for like wartime veterans. So you don't have to be 65 or older to use an elder law attorney, right? But we spend a lot of time doing asset protection planning for families so that they don't have to spend it all in the nursing home.
Asset protection is key. That's the key right there.
Yep.
Because nursing homes are very, very expensive.
Very, very expensive.
Yeah.
So, you want to have good care for your people and for yourself, forever.
Yes.
So you want to make sure you can figure out how you do that. So that's, I think, the number one thing is asset protection and trying to figure out how you're going to make that happen.
Yeah, because here in the Dayton area, the average nursing home monthly cost of care is between $12,000 and $15,000, and people don't realize that.
A month.
A month, correct. And sometimes there's also that misconception that Medicare will cover it, but it does not. It only covers for rehab, right, up to those 100 days.
Right.
And another misconception with Medicare is that it's going to cover those 100 days at 100%. And unless you have a proper supplement plan, you're going to end up having copays that increase every 20 days. So you could still be out of pocket $250, $300 a day in rehab, right? So that's another important part of kind of helping our seniors plan, is to make sure that they're making educated decisions about their Medicare.
And their health insurance.
I think that education is key, because so often we hear those numbers and we hear that, and many people are not sitting on, bank accounts prepared to pay that. And so I think there's, that bury your head in the sand and you just think, well, I don't know what I'm going to do.
Then when it comes,
that
it'll
sounds
be okay.
terrible and scary. I hope that never happens. And, having you here, I hope people can hear that being educated up front and just talking with someone about where your starting point is and how can I, make the best picture work for, my financial situation. There are, plans and solutions and strategies, and burying your head in the sand and waiting is not the best one.
It is one, but it's not a good one.
Yeah.
Yeah, and we always talk about just getting ready, and then hopefully whatever doesn't happen, but you want to be prepared for that.
Yep.
And so time, I think, is one of the keys for you. The less time you have, the less that you can help people, right?
Yeah, I mean,
ideally, what's the best time to start talking to you, I guess?
Well, I think talking to an estate planner in general, right, again, should happen when you're 18. It's something that those plans are going to evolve with you as your assets grow, right, as your family changes. Your health situation may change. So that's something that needs to be started early. And then as we're you're young, you're married, you have minor children, so maybe we're doing a revocable trust and we have a will and our power of attorneys. And then, that next stage of life, right? Our kids become adults, they have families of their own, maybe we're, reaching retirement. That plan that we had in place might not work for us anymore, might not accomplish what we're trying to accomplish. So as far as the asset protection piece, typically, most of our clients who come in and want to talk about that are normally probably around the age of retirement.
Okay.
Doesn't mean you can't do it before, but there are some downsides to some of that asset protection planning, in order to get that protection, sometimes we have to give up a little bit of control. So, somebody like me with 4 minor kids, I don't want to have all my funds locked up in a trust that my brother has to access for me, right? I need to be able to have access to that. But at some point, when I'm no longer paying for, tuition or just supporting them, then I might want to start doing some protection.
Yeah.
Yeah.
Okay.
So yes, typically
So-
retirement age.
So the earlier the better, just to talk in general.
Correct.
When you're starting to talk about planning for maybe long-term care or those kind of things, maybe retirement age.
Yep. Or, God forbid, that diagnosis, right?
Yes.
Somebody's diagnosed with early onset dementia, or you get a dementia diagnosis. I see a lot of, unfortunately, people who come to see me. I don't want to say it's too late, because I can always help, right?
Yeah.
I can, if I've got a married couple who one of them is going into a nursing home, I can still save everything, even, while they're there, okay? So it's never too late, but we have a lot of more options if we start early. So if someone that you know or love does have a diagnosis, come see somebody like me right away, right? Because we don't know when they're going to deteriorate to a point to need long-term care, if they ever will. But the sooner we start planning for that potential, right, the better we are.
Right.
The more options that it gives us if and when that time for placement arrives.
Okay.
If someone's preparing to come talk to you or have a consultation with you, what are the key things that they should gather? I know there's a long list of documents, but where should they start to get ready to talk to you?
Yeah, so estate planning also, when we sit down to do it, we think of it and look at it as a time to get organized, right? If crisis occurs, most of the time, whomever is stepping in for you probably doesn't know where your stuff is, right? They don't know how many bank accounts you have. They don't know where your IRA is. They don't know those things. So part of this planning process is putting all that stuff together and organizing, right? Maybe we don't need 11 bank accounts anymore, so let's consolidate. But most important, we're going to be asking for things like prior estate planning documents. We're going to be asking for asset statements, right? So your current bank statement, IRA statement, deed to the house, car titles, just kind of all of those things that demonstrate what you own and how you own it, right? Because when we do the planning, we want to make sure that your beneficiary designations, anything of that nature, comply or match the estate planning documents you're doing, right? Because a lot of people think if they do a will, they don't go to probate. And the reality is wills guarantee probate. But if we have, let's say in our will, we're leaving everything equally to our 4 children, and then we've got payable on death designations or accounts we own jointly with just one child, that will isn't going to govern that asset, right?
Yeah.
So we have to make sure that we're consistent in achieving whatever goals and priorities that client wants with their estate plan.
Okay. So, I think there's so many pieces to it. And so I think just talking to you helps to just kind of bring it into an easier path, right? So you're going to take all that stuff and you're just really going to have a big conversation with them about what their goals are
Correct.
and what they're trying to accomplish.
Yep.
And then it's different for different people.
Everybody's
right? So
different.
just talking to somebody else and going, oh, you did this, I should do that too, not necessarily.
Correct.
Right?
Yep.
So I think that's the key, is to just kind of find the right estate planner and just start talking to them early about it. So what are some mistakes that people make, and what are things that they do that you feel like, oh,
You wish they
I
would have.
wish you would have just had this thing or whatever.
Yeah.
Do you find some common ones?
Well, the biggest common one is they've done nothing.
Nothing.
Yeah.
Right.
80%.
Yeah. So, we get people who, let's face it, illness and injury typically is not planned, right? So part of the reason we do this type of planning in advance is kind of like why we buy car insurance, right? Or homeowners insurance. We're
Right.
hoping to never have to use it, but if something does happen, we have that coverage. So the same thing for your power of attorneys, right? We hope we never have to use it, but It's there if we do.
Right.
So, like, I'll give you an example. My dad, a couple years ago, my mom was in a car accident, totaled the car, so they got a new car. Then they both got COVID. And so they couldn't go get their tags, right, and the license plates and all that. So I took my dad's POA to the BMV and got their license plates and their tags so that they could have those for the car.
If they didn't have a P. Yeah.
Right. A week later, mom and dad are fine, recovered
Right.
from COVID, and so I'm not using it anymore. But if we didn't have that in place, I wouldn't have been able to help them.
And that's such a good point, because sometimes it's not, this giant diagnosis or you're ready to go into care. Sometimes it's like I had to have surgery and, somebody had to just take over for me for a
Right.
little bit.
Right.
Right?
Yep, 100%. So
Yeah.
not doing anything is the biggest common thing we see. The next thing that unfortunately we see, and a lot of times it's not the client's fault, is that the documents they had put in place aren't accomplishing what they thought they were going to accomplish, right? Whether that's the other attorney didn't ask the right questions, or they didn't succinctly state what they were trying to accomplish. But a lot of people think they've created an irrevocable trust when they haven't. Power of attorneys are done that they don't give enough powers to the agent to be able to do the things we need to do. Unfortunately, estate planning is one of those things that people kind of put on the back burner. They don't want to spend money on it. Nobody likes to see attorneys. So it's like the dentist, right? You only go if you have to. But most of the time people will be like, oh, my nephew is, a criminal law attorney and he prepared my power of attorney. Well, great. Hopefully he did it right. But it's kind of like a brain surgeon, right? If you have brain cancer, you're not going to go to a cardiologist to perform the surgery, right?
Right.
So why are you going to a criminal law attorney to get your estate planning documents done? Not saying that they aren't a great criminal law attorney, right?
Well, and at least they went to law school and you didn't just pull it off the internet.
Well, and that's that's the other thing that we see a lot too. Yeah.
And I mean, those things off the internet, I think exactly what we said. They are super generic, and so they don't know what you're trying to accomplish. They're just giving you like a super generic thing, which maybe isn't accomplishing what you want it to.
Yeah, and maybe because you just printed it off the internet, you aren't executing it appropriately.
Right.
Maybe you think you have this POA that you signed, but you never had it notarized. Or maybe the internet gave it to you and said you just need 2 witnesses. Well, in Ohio, it has to be notarized. Wills are witnessed. Other documents have to be notarized. So you may think that you have everything in place, but the reality is what you have in place won't work.
Yeah.
Yeah, I think we hear a lot too that word trust, the difference between revocable and irrevocable, people don't know. I don't think I knew before knowing you and being in, helping seniors in this industry for the last number of years. And I think people just are like, yeah, I have a trust. And
Right.
they think they're good, and it's
May
not
not have
doing
anything
what
in it. It might-
Yeah,
you
and
know?
that's another common mistake or that we see is people will have spent the time to do the trust, but then they'd never put anything in it,
Right.
And so that trust, they think that the trust owns everything or is controlling everything, but in fact it's not. We still end up in probate because we never had anything in the trust, right?
So trust is like a bucket? Like, just kind of talk to me like I'm 4 and tell me what a trust is.
Yeah, so typically there's lots of different trusts, right? So hence the reason you go in and talk to somebody, and that's why we ask, what are you guys trying to accomplish? That allows us to figure out the appropriate trust for you. But a trust is a bucket, and that bucket either owns the asset while you're alive. So for example, I have a revocable trust. My house is in my trust through my deed, right? So my deed says that it's owned by my revocable trust instead of me individually. Or you want to point the asset to the trust at death. So you would do that through like a payable on death designation, a transfer on death designation on a car title, for example, or through a beneficiary designation, like on the life insurance policy. So those are the 2 ways we fund. We call that funding, that bucket.
Okay. And that protects, why is that a good idea to put it in there?
Well, so when we're talking about kind of the purpose and the advantages of trusts, With revocable trusts, we do it so that we don't have any interruption in control of assets. In other words, we're avoiding what we call lifetime probate. So, for example, I have a POA and I have a trust, power of attorney, and a trust, and my stuff's in my trust. If something happens to me, my successor trustee is going to step in to access and continue to manage those items. But if they weren't in the trust and the bank, for whatever reason, didn't want to honor my power of attorney, now my family's potentially seeking a guardianship to be able to get access, right? So that lifetime avoidance. We also, in trust, have the ability to plan for those unforeseen circumstances, right? A beneficiary becoming disabled, you know, kind of doing some control from the grave, we call it sometimes, you know. So then when we talk about an irrevocable trust, that's the one that gets us that asset protection in 5 years. So we transfer, for example, the house into our irrevocable trust. Now we start that 5-year clock for Medicaid.
Because the irrevocable trust means that somebody else is in charge of it. So talk about that, the difference between the trustee and for a revocable trust and an irrevocable trust.
Yeah, so for trusts basically have 3 important parties: the trust maker or the grantor, that's the person creating the trust, and they're putting their stuff in that trust, right?
Okay.
Then we also have the trustee, who could potentially be the same person as the trust maker, could be somebody different. And then we have the beneficiaries, right? They're the ones that have access to the trust while the trust maker is living, and who would receive the assets in the trust after the trust maker passes away.
Okay.
Again, can be all the same person, they could be different. Revocable trusts, typically the trust maker, the trustee, and the beneficiary are the same person, right? So me, for my trust, for example.
Right.
And then if something happens to me, whatever's in that trust is going to pass to my kids, right? For an irrevocable trust, specifically the asset protection one, the trust maker cannot be the trustee, okay? So if I'm creating the irrevocable trust, I would have to make Jody my trustee. Now, Jody has control of the stuff in the trust, and the beneficiaries are going to be, say, my kids, okay? So I can't access, the trust maker, cannot access that stuff in that trust directly, right?
That's where the control thing
Yes, that's
can
where
sometimes feel scary.
Yes. And, you know, I tell people too, like we talked about starting this at, you know, around retirement age. It's not an all or nothing thing, right? Maybe we still want access to some of our funds so that we can travel or do whatever it is we want to do. Okay, well, let's put the house in the trust, right? Typically, that's people's biggest asset. At least we've started protection on that.
Right.
Then maybe 10 years from now, you know, I'm not traveling as much, so I'm ready to take another chunk of money and throw it in the trust and start my 5-year clock on that. So it doesn't have to be an all or nothing situation, right?
Explain why you need the 5-year clock.
So for Medicaid and long-term care, Medicaid has what's called a 5-year look back. So if we give assets away within 5 years of having a long-term care event and needing that Medicaid will penalize us for a period of time because we gave those assets away. So we want to put them in that trust before we have that long-term care event.
So we're essentially giving them away early.
Yes.
Essentially. I mean, whoever you have as your trustee, if they understand that they're still all yours until you're gone and, you know, whatever, and they work through that. But in the eyes of the law or whatever, we're giving them away so that we don't have them
in 5 years.
In 5 years.
Yep, that's correct. And, you know, I tell people, just because Jody is my trustee doesn't mean that I can't still have my annual meeting with my advisor concerning my assets that are in the trust and out of the trust, right?
Yeah.
It's just that if maybe I want to buy, you know, gold, I have to tell the advisor, hey, I want to buy this X, Y, and Z, and then Jody has to sign any documentation or approve that, right?
Right.
Also with the house, if the house goes in the irrevocable trust, you still have the right to reside. They can't evict you, can't charge you rent. So, you know, if you're giving it away, but you're retaining those tax benefits and the right to live there and all of that too.
What about selling a property out of an irrevocable trust?
So if we want to sell the property, again, the trustee has to be the one to execute those documents. And so, for example, we're selling to downsize, right?
Yeah.
So we sell the house, we net $400,000 from that sale. We're wanting to buy our new patio home, that's $200,000. So we sell the house from the trust, money flows into the trust, trustee buys our new house. That way we don't break any of that 5-year clock that we've already built.
And they buy it in the name of the trust?
Correct.
So it still is in the trust, the new one is?
Yes.
Okay.
Yep. Because that 5 years started when we transferred the first house to the trust. So if the house has been in there for 4 years, we don't want to sell it, give the money back to the trust maker, have the trust maker buy the house, and then put it back in the trust, because now
then
we're starting 5
restarting
years
the
over.
clock.
Yeah. Yep.
Correct.
And then something else, oh, go ahead.
So if you're putting different assets in the irrevocable trust, they're separate clocks for when you put different things in. It's not when you create the trust itself, because it could be empty, right?
Yep.
It's when you've
Funded
put your
it.
house in, funded it with other accounts, then the clocks can be started different times on different things that are included in the trust.
Correct.
But you don't need a new trust for each thing. So you just
No.
need one bucket. And as you put it in, you start counting 5 years from that day that you put that thing in the bucket.
Correct.
Got it.
Yep.
Yeah.
It's like a rolling clock.
Yeah.
Yeah.
So, so I think one thing that we didn't say when we were talking about power of attorney, because I think power of attorney and then trust and then irrevocable trust, it's kind of just layers of letting people have control of your things, right? And so, but power of attorney ends when you are gone.
That's
And I think a lot of people don't know that, because we have a lot of people that come thinking that if their loved one has gone and they're trying to sell the house with us, and they're like, well, I have the power of attorney. I'm like, well, it's over when you die.
Yes.
So on power of attorney, I think this is, a simple question, but I think one that a lot of people don't know. Can you have more than one power of attorney, like for your financial power of attorney? And how does that work, if so?
Yeah. So healthcare power of attorney, just one. And then we can have a succession. Financial power of attorney, yes, you can have more than one. You can have as many as you want, and you can have them joint, requiring them to make decisions in agreement, or they can be joint with the ability to act independently of each other. So there's obviously pros and cons to both of those. Most of the time when my clients are doing that, it's they're making both the kids POA, for example, because one is local and the other one's out of state, right?
Yeah.
And then we make them joint with the ability to act independently, so that if the one that's local is out of town or unavailable, the out-of-state child can step in and help mom and dad. If we make them joint, requiring them to act in unison, the downside to that is that if that decision, both of them have to make it, right? So
Yeah.
both of them have to sign the check, or both of them have to sign the closing documents to sell the house. So there can be, it can make things a little difficult, especially if we're not, localized to each other and we're spread out across the country.
Yeah.
Yeah.
Yeah, we want to allow them to help us in the easiest way
Right.
that they can help us.
Right,
That's
right,
the
right.
purpose of them, is to allow them to help us when we need it.
Yeah, and I should point out too, with power of attorneys, they do not have to live in the state of Ohio, nor does your executor or your trustee. However, if you end up passing away without a will and have to go through probate, now your executor has to be somebody that lives in Ohio. They have to be an Ohio resident.
Okay.
So, I get that question a lot too. My kids, none of them live in Ohio. Can they still help me? Yes, they can. And, as you guys know, the nature of business transaction these days, everything can be done mostly
Yeah.
online. So, or remotely.
People are always like, oh my gosh, we don't want to go to probate. We don't want to, but I don't even think they know why they don't want to. I think they've just heard they don't want to. So
Sure.
Tell us why you wouldn't want to, or, what, if you had to, you're not, it's going to be all right too. Like, just tell us that process a little
Yeah,
bit.
I mean, probate is like kind of that 4-letter word, right? But it serves its purpose at times, but the downsides of probate is typically it's going to take time, right? Most estates typically aren't wrapped up for at least a year. That's number one, because we have to wait 6 months before we can even start to close an estate, because that's the creditor statute of limitations. So when we go to probate, when an estate is opened in probate, we're opening that estate potentially to creditor claims. And we have to wait that 6 months. Additionally, there's court-imposed deadlines and time that has to lapse for certain things.
A lawyer that needs to help you.
Right. Well, you can do it without a lawyer, but it's every county in the state of Ohio has its own rules. So, even for us attorneys who do it, we have to know what's different with Warren County and Butler County and Montgomery County, So, and it's forms. It's very form heavy. So if you don't file the right form or check the right box, it's going to get rejected, right? So, and you're on the court schedule. That's just the way it is. We can't speed it up,
And from our perspective, being realtors and the house being the thing we deal with most, if you're on that, slow clock of the probate court, a house that's sitting there vacant and, with carrying costs of keeping utilities on and keeping the yard mowed and all of those things, if you, have to wait for that, year or more for probate, you're spending money before you can sell that asset and move that to wherever it was designated in the will. So even if it ends up going where it was supposed to, you will have spent money, and the house potentially had some deterioration by just sitting vacant, and all of that. So if you can avoid that, if the house is going to need to be sold, that's a great thing to avoid.
Yeah, and if selling the house is what we intend to do, most of the time that can be done inside of that 6 months. But we do have to, typically it's going to be 30 to 45 days before we get the executor appointed. And as you guys know, they can't sell the house until they have that letter of authority from the court.
Right.
It's kind of like a power of attorney, right? And that's what gives them the authority to sell. So people get frustrated.
Yeah, we've
about
seen
that.
that. Yeah. Okay, I just wanted to clear up because people are like, we don't want probate, but sometimes they don't know why.
Well, yeah. I mean, also it's public, right? So all of the filings that are done in probate court, your will, all of that stuff, we have to do an inventory of your entire estate. So, that's on the public record. Anybody can go on there and see. And again, opening your estate to creditors. So again, it has its place, but if we can avoid that and be able to be in the trust world and privately administer, things can happen quicker, and you have that control right away.
Right, and access to your funds if that's, you
Correct.
need that. So.
Going back to more what are probably simple questions for you, but to ask, what's the difference in a power of attorney and guardianship? Are those similar, totally unrelated? You've said both of them today.
Yeah. So a guardianship is when the court appoints someone to be in charge of us, right? And typically it's because we lack capacity. So guardians, we have both a guardian of the person, which is like a healthcare power of attorney, so they're going to make healthcare decisions, and then a guardian of the state, which is like your financial power of attorney, and they're going to be in control of the assets. You lose all ability to make decisions for yourself when you become what we call a ward or a protected person under a guardianship. Again, you have to be deemed incompetent, and I think the hardest part for your family, if that's the road that we have to go down, is we have to get court approval for everything, right? So we're filing inventories every year. We're accounting for every single penny they've spent. You're going to have an attorney. They can also create friction where we didn't necessarily need it, right? Because mom's going to have to be declared incompetent, and maybe she's got dementia and she might be incompetent, but she knows enough to say I'm not incompetent, and so it's not ideal. It's not an ideal place to be. Power of attorneys avoid that. The only time, if we have power of attorneys in place, the only reason typically you would need a guardianship would be if an individual is a danger to themselves and is refusing to leave home and go into an appropriate facility. Then you have to get a guardianship to move, to force someone to move, right? But
So
yeah.
talk about power of attorney and dementia. So if we get down the road of some kind of a dementia diagnosis, at what point can we not get a power of attorney? Like, let's just talk about that kind of.
Sure. So legal capacity is different than medical capacity. I've had several occasions where I've had nurses call security on me in a hospital because they claim this person doesn't have capacity to sign a power of attorney. And the reality is we don't have to understand to the dollar how much money I have in my account. Or, I don't have to sit there and make a list of all of my assets. It's really about understanding that I'm putting this person in charge, right? Knowing my relationship with that person. And sometimes it's just that we've already done a POA, but for some reason it's not being accepted, and so we need to do a new one. So we're just mirroring that, right? We're not changing what they did when they didn't have dementia. We're just updating it, right?
Yeah.
So I think it's really important. I hear probably 5-6 times a week I have phone calls with people who've been told by the hospital or the nursing home to call me so that they can get a guardianship. And so my first question is, do you not have a power of attorney? And then we go down that road. Probably in my 8 years of doing this, I've only not been able to get a POA executed on one occasion where they just
Did not have the capacity.
yeah. And that was because they had suffered a stroke, and they were just basically unconscious, right?
Yeah.
So, I couldn't I just couldn't.
Well, and I think that just reiterates the importance of choosing the right person, someone like you that has the nuances and the specialty of elder law, you know all those rules and regulations because the nurses and other people are there for the person's care and have their best interest at heart too, but they might not be giving the best advice because they don't have,
they're
the
not
wealth
lawyers.
the wealth of knowledge. They're not an attorney and
Yeah.
not specializing in that to know all the nuances that you do. And so, just because you're in that crisis moment, know the right people to ask the right questions to. People aren't going to ask you about the health next steps,
Right.
but they shouldn't be, relying on,
The nurses.
the nurses or
somebody.
social workers that should just be pointing to that elder law attorney for the best answers and get that great advice.
And also that just speaks to having the power of attorney ahead early, right?
Yes.
Just have it early, and then you have it.
Right.
And should anything happen, God forbid you get in an accident or anything,
Right.
stroke can just come on. You don't know. That's not a diagnosis. That's something that just happened.
Right.
So have that stuff done early.
Yeah, I think it gives your adult kids, that peace of mind too, of knowing that the decisions of your parents are laid out and you know what they want to happen, or at least who they want to start turning those wheels, and you have the confidence that you're making good decisions when it's been talked about as a family and
Right.
the paperwork's in order. It's hard to jump in and make those decisions when you're just not quite sure.
What they wanted.
Yeah.
Yeah, because I think if you're going through the process of getting those papers done, you can have, like you said, a conversation. What does mom want? What does she want later? Because we don't sit around and talk about that very
Right.
often. But as long as as the person who's being responsible down the road, if you need to, you get to have those conversations when mom's feeling great and or dad's feeling great or whatever, and know what they want in the future, not when they're trying to make decisions out of crisis, which stinks.
Yeah, we always say estate planning really is done more for your loved ones than for yourself,
Yeah.
right? That's when you're dotting those I's and crossing those T's and making your wishes known and organizing and putting everything together, you're making it easier on the kids or your spouse or whomever that may be that's going to have to step in and help, so that when, God forbid, the Lord decides to take you, they aren't sitting there trying to go through and find documents. Instead, they're actually getting to spend the time grieving and remembering you instead of trying to deal with probate court
and feeling good about knowing that this is what you want or this is what you had wanted, and not having to try to figure that out themselves. And I guess I'm going to do this, or that's hard.
Yeah.
People think sometimes if I do these documents, I'm going to die, right? Like, it's like, no, I promise.
Right. We just are such advocates for just being ready, just getting the stuff together and be ready for whatever's coming. So
Yeah, and if you've done it once to get yourself organized paperwork-wise, just reviewing it periodically, it is not difficult. It's just like, here's what's changed here. It's easy. You have that habit of doing that, and then it's not a weight of, oh gosh, I'm not ready for the future.
Right.
So.
Yeah. And, we, in our office, if you become a client of ours, we want you to stay in contact with us. We want annual reviews, every 3 years at a bare minimum. We want you to call us if you sold your house and, you're buying a new one. I think it's important if you're looking for an estate planner that you make sure you find somebody who can create a relationship, because life's going to change. Laws are going to change. You're going to need to update documents. And then when those documents need to be used, ideally you want the kids or your spouse to have somebody they can reach out to and say, what am I supposed to do?
Who knows you and who's talked to you and knows what you're trying to accomplish.
Knew what that plan was. Yeah.
Thank you so much for talking to us today,
Yeah,
Rachel.
of course, my pleasure.
Yeah, it was great to have you. So lots of great information here. We'll have you back because there's lots more that we can dig into in this.
Yeah, if you need resources, you can always reach out to us on our website, www.downsizingroadmap. And thank you again, Rachel. We'll be back.
Talk to you next time.
Thanks for joining us on the Downsizing Roadmap podcast. If you found this episode helpful, be sure to subscribe, leave us a review, and share it with someone who might need a little downsizing inspiration. Have questions or ideas for future episodes? Visit us on our website, www.downsizingroadmap.com. Until next time, let's keep simplifying and moving forward.